All right, so we're going on.
Yeah, it's a third degree.
Okay, so more of it. All right, so are you Perry Robertson?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
There you are.
Mr. Robertson, in cause number 25 DCCR 0498, you're charged with...
Stop right here. This is where the case quietly turns serious. When a judge begins by anchoring the record with prior convictions, it's not small talk. In Texas courts, history isn't background noise, it's leverage. The question stops being, what did you do this time, and becomes, how many chances have already been given?
The state jail felony offense of evading arrest or detention with previous convictions, and that's from March 23rd of 2025. The indictment alleges you were previously convicted of evading detention February 23rd of 1998, and then again January 10th of 2000. And then it further alleges you were convicted previously of possession of a controlled substance, a state jail felony, April 22nd of 1999. Then after that was final, you were convicted of delivery of a controlled substance, a state jail felony, November 20th of 2000. And then after that, possession of a controlled substance, a state jail felony, November 4th of 2003. And then convicted of two delivery of controlled substance, state jail felonies, June 13th of state jail felony offense.
That was a lifetime resume of repeat offenses. Every conviction the judge reads tightens sentencing options and strips away flexibility. By this point, rehabilitation isn't the headline anymore. Pattern is. And courts take patterns personally.
2005. After that, convicted of possession of a controlled substance, a state jail felony, February 19th of 2008. Again, convicted of possession of a controlled substance, a state jail felony, April 12th of 2010. And unauthorized use of a motor vehicle, January 7th of 2010. And then finally, possession of a controlled substance, a state jail felony, July 29th of 2024. And how do you plead to that charge? Are all of those prior convictions true? Did you enter your plea of guilty and true to all of those convictions freely and voluntarily?
Yes.
And because they're all actually true?
Yes.
All right, I do want to know, what was that what did he get last year?
Wait, I believe.
Possession of a controlled substance, July 29th, 2024. Cause number 24, DCCR 0025.
State jail.
State jail.
State jail time.
Yes, state jail.
Okay. You ever been to TDC on any of these cases? Okay. So you understand if I follow that agreement, you're waiving your right to appeal, right?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tender's number one.
No objection.
It's admitted. Is there any evidence that Mr. Robertson is not competent?
No, Your Honor.
And the agreement is for a dismissal in 0499, correct?
No, there's
he's
two
pleading.
cases.
Two cases, Judge.
What did I just read?
CC.
Oh, to run CC. Sorry. Let me go through. So then, that helps me. Hold on. I got to write this. All right, in cause number 25, DCCR 0499, you're charged with, give me a second, the state jail felony offense of burglary of a building from March 7th of 2025. This indictment alleges all of those same prior convictions that I read out previously? And how do you plead to this charge? And again, are all of those prior convictions true? And are you entering your plea of guilty and true in this case freely and voluntarily? State tenders number 1 in that case as
No
well.
objection.
It's admitted. Any evidence that Mr. Robertson's not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty, and cause number 25 DCCR 0498 finds you guilty of the state jail felony offense of evading arrest or detention with previous convictions. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you...
This is the moment most people miss. 5 years on 2 cases sounds brutal until you hear the word concurrent. That means 1 clock, not 2. In a courtroom stacked with past convictions, this isn't luck. It's negotiated survival. The system punished him, but it didn't bury him.
You've been in custody that the law gives you the right to receive. In cause number 25 DCCR 0499, also find that you entered your plea of guilty freely and voluntarily, and those pleas of true. Find sufficient evidence to find you guilty, and at this time find you guilty. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you in each of those cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. They will run concurrently, which means together at the same time. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right? Good luck to you, sir. You can go back with the bailiff.
Good luck, man.
Good morning. Are you Burton Edward Bailey?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Excuse me, he will, Your Honor.
Mr. Bailey, in cause number 25 DCCR 1380, you're charged with the state jail felony offense of theft of property with previous convictions, and that's from August 9th of 2025. The indictment alleges you were previously convicted of theft May 13th of 1991, and then again January 11th of 2024, and then August 29th of 2024. And then it further alleges that you were convicted of possession of a controlled substance, a state jail felony, October 2nd of 2008. And after that was final, convicted of possession of a controlled substance, a state jail felony, October 26th of 2011. Convicted of delivery of a controlled substance, a state jail felony, May 11th of 2012. Convicted of possession of a controlled substance, a state jail felony, October 5th of 2018. And then convicted of possession of a controlled substance, a state jail felony, July 31st of 2024. And how do you plead to that charge?
True.
Well, are you guilty or not guilty of the theft?
Guilty.
Okay, and are all of those prior convictions true that I read out?
Yes.
All right. Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And did you plead guilty and true because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
I need to know what some of those prior punishments were. I feel like this is incredibly low for that amount of criminal history.
I'll let you know, Judge, that we took into account, I'm not to share prior with you, but we took into account, and Mr. Rojas can speak to this, the nature of the underlying offense, theft of clothing and cleaning supplies, Your Honor, from a, I forget the name of the establishment, but nevertheless, to answer the court's question, well, here, I'll just give you this.
Well, let's start with the last one from just July of a year ago, 2024.
77 days on that particular jail charge.
Okay. And then that's the only Jefferson County. We've got some Tarrant County.
In the interest of full disclosure to the court, he does have a 1994 federal conviction for what they term or refer to as take motor vehicle by force. He did 140 months on that. And then on his supervised release, when he was released from that 140 month sentence, his supervised release was revoked to a 10-month sentence, Judge. Again, the state's thinking was the underlying nature of it.
No, I understand that. I just, do you know the Tarrant County?
What year was that?
The 18, there's one from 18.
I'll show a POCS from 2018. He did 6 months in jail,
Okay.
probably state jail.
Yeah, they were all state jails, so it's,
He does have one real felony that did 5 years on. That was back in 1991, Judge Raquel.
That's right.
okay,
That and the federal case are the only substantial time he's got.
okay. All right, Mr. Bailey, do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Bailey is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of evading arrest with previous convictions. Find all of those prior offenses true. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. Thank you. Thank you, Mr. Coleman and Mr. Rojas. Good morning, you're John Dre Willis, and this is 25 DCCR 1048. Mr. Willis is charged with burglary of a habitation. What is the announcement?
Judge, I can, if you, okay. He was here on October 21st. The complainant in this case had signed a non-prosecution affidavit. She came to court that day, and during the pendency of the court process, she got my attention. We went to the back, and she said, I changed my mind. I don't want to do it. I want him to be held some kind of responsible. Based on that fact, I took that non-prosecution affidavit, kind of out of the equation, and the court imposed the bond conditions by agreement
Yeah,
that the bond would be reduced at $7,500. He was to have no contact with her or GPS, and he had to go and live with his mom in Iberia Parish,
Correct.
and we have the address. He has obviously not made that bond in the interim 6 weeks or so. She has not reached back out to me, but in light of that fact, I don't feel comfortable making the offer that has been requested for a misdemeanor. I would be willing to offer a felony probation with the same conditions pending a PSI. I just think a PSI would be important. I've tried to call her this morning with no answer. I can either make that offer pending a PSI, or I could ask you for 1 week and see if I can get a hold of her. I just don't want her to feel blindsided by it because she's gone back and forth. I'm not saying that she hasn't gone back and forth, but I think There needs to be some things in place. There was also a gun involved. We were able to determine that she actually found it and it was not as big of an issue as we had initially thought, which is why my willingness to make the felony probation offer, I just think that's in my best interest. at this
So why
time.
don't we do this? I mean, I did reduce that bond. I found that. Let's reset it to next Tuesday. See if you can get in touch with her, if that changes anything with regard to any agreements. And if it doesn't, then I would potentially reconsider that bond number to something that he was able to make with those same conditions. I think that would be proper for everyone's safety, but we could make the same conditions with a lower bond. So let's reset it to next Tuesday, and we'll see what the state finds out. Okay? We'll see y'all next week. All right.
I did talk to Detective Jackson, just FYI, I let him know that you're